Hi, this is Irina Shea, and this is part of our Wealth and Wisdom series. Today, we're going to talk about what happens if I die without a will in Bergen County, New Jersey. So, I'm going to share my screen and walk you through what happens if you do not have anything in place. I am going to you can follow along if you'd like by going to bergencountysurrogate.com and choose the tab titled Intestacy. So, a person who dies without a will is deemed to have died intestate. That means their assets have nowhere to go unless they have a direct beneficiary designation. But as of right now, a house cannot have a beneficiary designation in New Jersey. So, for most people, there's at least one or two assets that you can't simply avoid a will for. So this is very well written by the court itself on what happens if someone dies without one. So the estimate is here that 1/3 Bergen County residents do die without a will. So it is strongly recommended that you're not one of them. And there are various problems. First of all, who's in charge? When you write a will, you're naming an executor. It's usually your spouse, adult child, or a trusted person in your life. If you don't have that, instead, you're going to get what's called an administrator, and that's someone who has to step forward. Next of kin, for example, has to step forward to administer the estate. I believe that are your choice, not the court's choice. Okay. And also, there's going to be requirements for various disclosures and notices. And importantly, the administrator has to post a bond. So the bond could easily be more expensive than doing an estate plan itself in the first place. So you're not saving money, you're just deferring cost by not having done a basic estate plan at a minimum. So, there may be various people who step up to serve as administrator. It's not that you've named one person. It could be your second spouse, your adult children, your stepchildren. I mean, it's a mess. People might be fighting over this, okay? So you definitely want to avoid that. And then most importantly, who gets the assets? It's not just spouse, then kids. It's not that straightforward. It depends. So if you look at this section here again on the court website, it says who gets what depending on who is then living. So if you have parents then living, even if they're older, they're going to get a share. Your spouse does not get it all. And half of our clients these days are blended families. So we have second spouses or even third. We have stepchildren. We have parents ailing and possibly getting ready to go on Medicaid. These are not the outcomes we want. It's the default, if you will, of intestacy is pretty much what no one wants. So even the court here on their own webpage is begging you to please do an estate plan and get things in order because these defaults are generally not desired by anyone. And obviously complex because now we have to allocate shares depending on asset balances, et cetera, et cetera. It's messy. Okay. So I encourage you to read this. And the action item, of course, is do a basic estate plan at a minimum. Every adult walking around really needs, at a basic level, a will, a power of attorney, and a healthcare directive just to cover the possibility of their incapacity or passing. And it's one of the better things you could possibly do for your loved ones is to leave things in order. If you'd like to learn more, please go visit our website at irinashea.com and there is a Get Started tab. There are no charges for our consultations. Thanks.